mask, so speak as clearly as you can through your mask, so I can understand what you're saying. We have two cases on the docket today, you do, and in one case, your name is listed here on the docket as Cleopa Abston. In the second case, they have listed it as Cleopa Abston Henderson, which is correct.
Okay, so real quick here, the judge is saying that we basically have two different charges with two different names. One has the last name included of Henderson, Abston Henderson, and one just has Abston. The judge is asking him which name is the correct name.
Legal, which is correct. Abston hyphen Henderson, sir? Henderson. Okay, and where does the Abston come in? Social Security. Okay, then I'll address you that way.
Judge is probably getting ready to explain his charges to him.
Mr. Abston, in your first case, you're charged with especially aggravated kidnapping and tampering with or fabricating evidence in a criminal case.
Okay, so that's the two different charges.
Your bond was set by the Judicial Commissioner in that case in the amount of $500,000.
Okay, this is really weird right here. So first question, why is the bond only $500,000? Now, I realize to some people that's going to be a lot of money, but you don't pay the whole bond. If you post bail, you post a portion of the bond. The reason I'm saying why is it $500,000, when he was convicted of the exact same charge, the primary charge, back in 2000, the bond was set at $750,000. So why has the bond been decreased by 33% in this case? Does the judge know something that we don't? Well, he probably does. He probably knows that this gentleman's not going to be getting out today anyway because he already has some other pending charges. And that's the one that everybody on YouTube keeps saying, this is his first court appearance for the murder. This is not the murder appearance. This is the basically the kidnapping charge. This is not the murder appearance.
In your second case, you're charged with a misdemeanor offense, theft of property with a value of one.
Okay, the misdemeanor was added on Saturday, I think, less than $1,000. I think this is for the cell phone.
$1,000 or less, identity theft, and fraudulent use or possession of a credit card. Your bond was set in that case in the amount of $10,000 by the Judicial Commissioner. You're presumed to be innocent of the charges. You have the right to have a lawyer to represent you on these charges. And that is why you were asked to fill out some information for me for each case in an affidavit.
That's basically an indigent affidavit. Do you have any money? When they say, do you have any money, they're talking about everything. Do you have any stocks, bonds, 401k? Do you have any equity in any property, whether it's a home? Do you own a vehicle that you can leverage? Do you have personal property, personal possessions that you can, put up as collateral?
Similar to this one, you have two. One for each case. Raise your right hand, sir. Do you swear or affirm that the facts and the information that you are submitting in each of your affidavits concerning whether you can make bond and whether you can hire an attorney is true and correct information, sir? Put your hand down. In each of your affidavits for each case, you state that at this time you are not able to make bond, have no one to help you, and you're not able to afford a lawyer. Is that correct? Your affidavits will be filed here in each of your court jackets. And based upon your affidavits, I'm going to appoint an attorney to represent you. You'll be assigned a lawyer, appointed counsel, from the Office of the Shelby County Public Defender. I'm referring your cases today to the office and holding your cases over for a short continuance so they can assign a lawyer to represent you who will review.
Okay, so quick recap of what's going on here. Again, it's an arraignment hearing. This is where they're going to set bond and assign an attorney to you. He's claiming indigent. so he doesn't have any money to pay for an attorney out of pocket. It's pretty normal, really. I don't know if you've priced an attorney lately, but they're pretty damn expensive. You're not going to get a criminal defense lawyer that's going to get you off of something like this for no $200-300 an hour. You're going to be paying $500, $600, maybe $1,000, maybe $1,500 an hour. So the judge is saying we're going to assign you an attorney, and then we're going to do a holdover, which basically means you're going to have to hang out in the jail for a while. He's probably being held in the county. You're going to have to hang out in jail for a little while until we can get the attorney in front of you and you guys can talk.
Your cases and the facts, yes, ma'am.
If you're wondering who the lady is that just approached near the judge, that's actually going to be his defense attorney. She's got game. Stick around for a couple of minutes and wait and see what she pulls.
Good morning, Your Honor. On behalf of the Shelby County Public Defender, I'll accept the appointment.
Okay, so she's saying I'll accept the appointment through the public defender's office.
The case will be my matter.
All right, you'll sign on both jackets, Miss Jennifer Case.
He's saying, look, you just got to sign off on the case file, saying that you accept these cases.
Will you sign the jackets for me, please?
Yes, Your Honor. I will also advise the court that I'm at this time filing a motion for restriction of extrajudicial statements.
Okay, she's already started. She's a clever one. She's basically saying that she wants a gag order already. That's not something you would normally do in an arraignment hearing. But listen to how this goes down.
By prosecution, by law enforcement, witnesses in the case.
You can file whatever motions you need to at this time.
And Your Honor, I'll be asking the court for order.
Just to advise you, know, if you've spoken to Mr. Hagerman, I understand that there are additional charges that are forthcoming. I don't know how you want to handle this.
Okay, so the judge is asking her, hey, by the way, have you talked to the prosecutor's office and do you realize there's additional charges? The additional charges are the murder charges. That's what he's talking about. That's what the judge is talking about. Now listen to the prosecutor's office response.
Today.
I'd say a couple of things, Your Honor. First, with regard to this motion, I think she said something to the effect of preparing an order. The state intends, as we always do, to comport with the ethical rules about what we can say and what we can't say. I don't understand a request for any sort of gag order at this time. This is literally the first court date.
I haven't seen it yet.
Okay, so the prosecutor's office is saying, what in the hell are you talking about? We just got here. Nobody's issued anything, any public statements, be it police or the DA's office or whomever. What are you talking about?
There's nothing in the record right now. I haven't seen a written motion. If and when a written motion is filed, I will review it and rule on it. I understand. You'll have the opportunity to be heard.
Very good. The second thing, Your Honor, is yes, additional charges were filed this morning for murder, premeditated murder, and murder in perpetration of a kidnapping. I would expect the Judicial Commissioner to send those cases here, the clerk's office to send those cases here, as Your Honor stated. I would expect them to defer to Your Honor with regard to a bond setting on those cases. I think it would normally come to this court with no bond set. And I think it would make the most sense, just record keeping and everything else right now, to go ahead and show no bond set on this matter as well, so we get everything.
Okay, so the prosecutor is saying, hey, by the way, you probably already know this, but we did file charges this morning, actually, for the murder. It's 3 different counts. You can back the video up and listen to them all over again if you want. I'm going to try and keep this video as quick as I can. The prosecutor's office is basically saying, we would prefer that you hold this one over, this particular case right here. This is the kidnapping charge. We would prefer you hold this over with no bond.
Straight in the record.
If there's going to be any motion filed to reduce bond or set no bond or revoke bond, I want it in writing, in the record. Under the section, a bond has been set by the...
Okay, judge is saying, I'm not going to do anything on the spot. If you want to have another hearing on this bond issue or the amount of the bond for this particular case, the charges that he was charged with on Sunday, day before yesterday, you need to file a motion.
Judicial Commission at this time. That's fine. If there's going to be any request by the defense...
The judge knows this is going to be a high-profile case. He doesn't want any slip-ups or mistakes.
To reduce the bond or change the bond, it must be in writing per the statute. If there's a request by the state to change the bond, increase it, revoke it, or anything like that, it must be in writing. So if you'll file your motion to have it in the record, then we can deal with that. It's not before me right now. The case is not in front of me, and it requires a written motion.
The judge is saying that those murder charges, those aren't in front of me. They haven't been assigned to me. You filed them. They haven't actually been recorded and assigned to this court. There's multiple courts, multiple judges, right? The judge is saying, if I get them, I'll rule on them. If I get those charges, I'll rule on this bond that you're talking about. But I don't have that case. I can't rule on it. And if you want to file a motion to pull the bond, you can do that, but you got to do it after I get the cases.
By counsel for the defendant, for the state, to file a written motion if there's going to be a change in pay. All right? Thank you. Appreciate that. Now, I'm assuming, now we can't assume that the clerk's office is going to assign the case to this courtroom. I'll have to ask them to specifically do that.
Okay, all he's saying right there is he'll have to get with the clerk's office and tell them to go ahead and assign the murder charges to his court because he already has the kidnapping charges.
Unfortunately, too many times when cases are pending in one courtroom and a person's charged, the clerk assigns it to who's next on the assignment. So I'll have to make a phone call down to the clerk's office and request that they set the case if the charge has been filed. Set those cases with new charges in this court. It'll be on the docket in the morning. So I don't know if you want to hold this until the morning or
I would also ask that perhaps the court hear our motion tomorrow and just file a written motion.
well, I'll
Okay. Oh, she's a tiger. Okay, so the defense attorney is saying, actually, let's just hear it now. If you'd like to hear our opinion, can you hear it now? Can you hear me now?
take it up if and when it's filed and give the state an opportunity to look at it, read it, and see if they want to respond to it in writing. So let's don't do oral motions on the first day. Let's don't do that. Let me get it before.
Okay, so there you have it. It's this is going to be a good trial from a defense perspective. I say he's got even though it's pro bono. I don't know if you guys understand how the attorneys go into the cycle or the pool for pro bono work. Actually, this isn't really even considered pro bono. Their office still gets paid, but for a court-appointed attorney, first thoughts, he's got a pretty decent attorney.